2023 Illegal Trial Notes. Name: Kevin Perelman State, California County, Los Angeles, Van Nuys Courthouse. Case: LA 099813. Legal issue: criminal conviction, seeking complete dismissal, with prejudice, no retrial. Primary goals: vacate conviction, and have entire case dismissed prejudice due to cumulative constitutional violations. Ineffective assistance of counsel and courtroom misconduct. Chet Zeverman. Specific accusations: discriminatory and prejudicial comments. Chet's statement to me, right before the verdict, "You might get away with this," showing from day one he was acting as a judge, not a lawyer, and was never going to represent me fairly, and was involved in a conspiracy to lock me away no matter how innocent, no matter how much proof. He wasn't even going to try to prove my innocence. Everything asked, he gave an opposite answer and disinformation, showing anger. I asked about change of venue. Like change of venue, he lied, stating there was not grounds for. While was friends with a lot of the judges. Being provoked and harassed by witness Terrence Scroggins before and during trial with over 250 plus videos, which could have been presented to the jury. Would not help with filing restraining orders or use the information to show in the court at any time that Terrence was always the aggressor, or impeach the witnesses properly, jumping from lawyer to lawyer. Penal Code Section 147, willful deprivation of a client's rights. Failure to investigate, prepare, defend. Association with Aleph Institute, prejudice and collusion. In 2018, during the appeal process, attorney Seymour Amster worked with Deborah Baer of the Aleph Institute, a Jewish organization, who stated I was anti-Semitic. This defamatory claim was made despite my Jewish heritage and history of being targeted for not conforming to certain religious or cultural expectations. The labeling was used strategically to prejudice the court and Jewish community against me, undermining my appeal and denying me equal protection. This demonstrates that the appeals process itself was sabotaged by religiously motivated bias, collusion, and intentional misrepresentation of my character. The coordination between Amster, Baer, and Aleph shows intent to intentionally lose the appeals rather than zealously advocate for my rights. 2. Judicial corruption and misconduct. Previous subsections unchanged. Community influence through Aleph Institute. The Aleph Institute, via Deborah Baer, actively manipulated public and judicial perception by branding me anti-Semitic. These false claims carried weight within the Jewish community and influenced judicial officers who had associations with Aleph. The involvement of Aleph demonstrates community-based corruption, intertwining religious prejudice with judicial bias. Did not review Kevin's exculpatory video evidence or ask for Kevin's version of events. Relied on fabricated reports and prosecution narrative. Penal Code Section 1054.9, failure to seek or present exculpatory evidence, and linked ties through the people in the Jewish community mad at me for kissing a black girl based on the worldwide hatred I'm not allowed to talk about. Failure to file key motions. Judge Dohe refused to file pitch motion for LAPD officer Charles Sean Dintz, despite Dintz's federal lawsuits for similar behavior. Would not request change of venue or move for mistrial, nor file dismissal. Even with the events happening in the courtroom. Penal Code Section 1054.5, withholding of motions/evidence. Conflict of interest. Admitted being friends with Judge Gregory A. Dohe and Judge Stephen Marcus. Failed to zealously advocate for client. Potentially took $50,000 under false pretenses, with influence from Arnold Zilber, Kevin's stepfather. Penal Code Section 182A5, conspiracy to obstruct justice. Coercion toward insanity plea, NGI. Tried to pressure client to plead NGI to get you out of this, abusing attorney's power/trust. Stating, "I can get you out of this, I know some psychology people." Business and Professions Code Section 6068, duty to act with honesty and loyalty. Refusal to provide self-defense argument. Refused to present documented mobbing/stalking history. Said self-defense not possible for vandalism despite clear evidence of gang stalking and conspiracy amongst mass stalking groups with LAPD. with an agenda to set up or frame the defendant. Penal Code Section 692 to 694. Legitimacy of self-defense argument. Judicial corruption and misconduct specific accusations. Bias and prejudice. Judge Stephen Marcus. I'll squeeze you out of your place. Judge Gregory A. Dohe. Fabricated mental health diagnoses, belittled and intimidated defendant. Come on down. Treating courtrooms and trials like fun game shows. Denied defense motions for pitchess. Colluded in systemic prejudice. Penal Code Section 96 and 96.5. Judicial officers acting corruptly, maliciously, or with conflict of interest. Van Nuys court reporter who owns property adjoining my wall misconduct, Debbie Woolman. Spread false rumors about Kevin's mental health to court staff and judges. Owned property adjoining defendant, conflict of interest. Omitted critical exculpatory phrases from transcripts, e.g., every miata is modified. Penal Code Section 134. Preparing false evidence. Tampered transcript. Penal Code Section 182. Conspiracy. Police corruption. Officer Charles Sean Dint's specific accusations. History of lawsuits and misconduct. Used Facebook to incite neighborhood harassment against Kevin, earlier federally sued by Rex Schillenberger. Publicly posted, how do we force people into mental facilities, inciting community intimidation / hate / stalking groups. Penal Code Section 182, conspiracy to violate civil rights. Penal Code Section 135, destroying / concealing evidence. Fabrication of claims and evidence. Lied about Kevin following him with prosecutor Orble to use as ammo for increased sentencing. Staged incidents to provoke legal trouble. Seized our computer, falsely called a hard drive, made misleading claims about data. Penal Code Section 118. Perjury. Penal Code Section 141. Planting / tampering with evidence. Intimidation and collusion. Orchestrated use of fake FBI agents to intimidate Kevin in courtroom right before trial day. Colluded with prosecutors Lisa Orbelli and Detective Ruiz and Charles Sean Dint's. Penal Code Section 136.1. Witness / victim intimidation. Penal Code Section 182. Conspiracy. Witness and community misconduct. Specific accusations. Terrence Scroggins, neighbor / witness. Engaged in continuous harassment / provocation before and during the trial. 240+ videos. Staged vandalisms with neighbors, provokings, submitted false restitution claims, colluded with USAA Insurance to repaint entire car, then sought extra $5,000 after USAA paid for repairs. Left blackmail threats in writing demanding direct restitution money. Penal Code Section 518, extortion. Penal Code Section 118, perjury. Pedram Espinoza, neighbor / witness. Provided knowingly false testimony about his time at the property and his encounters with Kevin. Penal Code Section 118, perjury. No impeaching the witness with Pedram on video stating, I'm not allowed at my townhouse complex. Or that I take pictures of kids. Showing he's defaming my name and has motive to get rid of me. Shep kept the argument in a context to make it look like I was loitering around his house in the common areas of our complex. A juror had to ask the judge how long I lived there. He picked up on the one-sided stories. Community members, Yossi, Jason Ryan Fishman, etc., participated in organized surveillance / harassment, repeated slander, not a real Jew, mentally ill, acted at direction of Officer Dint's and Neighborhood Watch. Penal Code Section 653.2, electronic / cyber harassment. Penal Code Section 182, conspiracy to harass. Showing linked events within the Jewish community. Prosecutorial misconduct specific accusations. Lisa Orbelli and Detective Ruiz, prosecutors. Collaborated with police and witnesses to create incidents for prosecution, made false claims and permitted intimidation tactics in and around the courthouse. Permitted / introduced false evidence, allowed staged intimidation, fake FBI agents, and courthouse staff. Penal Code Section 118, subornation of perjury. Penal Code Section 182, Conspiracy, Penal Code Section 96.5, misconduct by officers of the court. Transcript, records, and restitution tampering specific accusations. Omitted or altered evidence/testimony in trial transcripts, Debbie Woolman. Docket/minute orders contained unexplained errors or clerical manipulation, split sentence, no probation issues, possibly at the direction of corrupt clerks and neighbor/court reporter Debbie Woolman. Restitution awarded based on fraudulent insurance claims and blackmail tactics, Terence Scroggins. Penal Code Section 134, preparing false documentary evidence. Penal Code Section 115, filing false instruments. Overarching constitutional and civil rights violations. Specific accusations. Constitutional. Denial of due process. U.S. Constable Amend. 14. Denial of effective assistance/counsel. U.S. Constable Amend. 6. Strickland v. Washington. Denial of fair trial and equal protection. California Constable Art. I. Section 715. Pattern of systemic government abuse. Collusion among judges, defense, prosecutors, police, and community. Tampering, intimidation, and long-term targeting that makes fair retrial impossible. Penal Code Section 182. Criminal conspiracy. Civil remedies. 42 U.S.C. Section 1983. Federal civil rights suit for deprivation of rights under color of law. Judicial corruption. Grounds for dismissal overlooked. Repeated judicial bias. Judge Stephen Marcus made overtly hostile comments toward defendant. I'll squeeze you out of your place, demonstrating clear personal animosity and prejudice contrary to impartial adjudication required by law. Judge Gregory Dohe fabricated mental illness labels for defendant with no clinical basis, belittled defendant during proceedings, and denied valid defense motions, e.g., Pitchess motion for Officer Dintz, demonstrating pattern of prejudiced rulings. Legal basis. Judicial bias and partial are grounds for mistrial or dismissal. Caperton v. A.T. Massey Coal Company, 556 U.S. 868, 2009. Extreme judicial bias may violate due process. Cal. Penal Code Section 96, Section 96.5, corrupt conduct by judicial officers. Court reporter misconduct and transcript tampering. Debbie Woolman, with a direct conflict of interest, fabricated negative mental health rumors about defendant to judges and staff, and altered the official record, omitting exculpatory testimony such as every miata is modified. Legal basis. Cal. Penal Code Section 134, preparing false evidence. Section 182, conspiracy to pervert justice. Police officer corruption, grounds for dismissal overlooked. Officer Charles Sean Dintz's documented corruption. Used his Facebook account to incite community mobbing. How do we force people into mental facilities? Was previously federally sued for similar actions. Lied under oath about defendant following him with prosecutor or belly for increased sentencing. Fabricated incidents and seized defendant's computer misrepresenting both its contents and evidentiary value. Regularly engaged in provocation and intimidation designed to escalate defendant's legal peril. Legal basis. Cal. Penal Code Section 118, perjury. Section 141, evidence tampering. Section 182, conspiracy. Section 147, officials depriving rights. Cal. Evidence Code Section 1043 etc. Pitchess motion. Officer history of dishonesty/abuse is grounds for discovery, impeachment, and, where egregious, dismissal. Prosecutorial misconduct, compelling grounds for dismissal ignored. Fabrication, call, and use of false evidence. Prosecutors Lisa Orbelli and Detective Ruiz collaborated with Dintz, Scroggins, and others, knowingly presenting false or uninvestigated claims to the court. Prosecutors enabled and facilitated courtroom intimidation, including the appearance of people posing as FBI agents during trial, creating an atmosphere of threat and unlawfulness. Prosecutors injected irrelevant hearsay and prejudicial evidence into the record, repeatedly straying from the charges to paint defendant as dangerous or unstable, manipulating judicial perception and deliberation. Legal basis. People v. Batts, 2003, 30 Cal.4 Teach 660, 693. Dismissal appropriate in egregious government misconduct. Cal. Penal Code Section 118, Subornation of Perjury, Section 182, Conspiracy, Section 96.5, Prosecutorial Misconduct. Admission of hearsay/irrelevant allegations. Prosecutors repeatedly introduced and relied on one-sided prejudicial statements and hearsay incidents, statements, rumors, alleged threats, and unrelated community disputes, irrelevant to the charged offenses, used solely to inflame and manipulate the judge and jury. Defense counsel failed to object or move to strike these prejudicial and improper references, compounding the miscarriage of justice. Legal basis. Cal. Evidence Code Section 1200, Hearsay Inadmissibility, People v. Fuyava, 2012, 53 Cal.4 Th 622, Admission of repeated, irrelevant misconduct evidence is reversible error. Cumulative misconduct clearly justified dismissal. Pattern of collusion. Combined judicial, police, and prosecutorial bias, evidenced by intimidation, tampering, and fabrication, destroyed any pretense of fair trial. Egregious conduct rises to the constitutional standard where the only appropriate remedy is dismissal, as retrial would merely replicate injustice. Missed opportunities for relief. At each stage, pre-trial, based on evidence fabrication/transcript tampering, during trial, judicial bias, police perjury, prosecutorial hearsay, intimidation, and post-trial, restoration of rights, clerical errors. Counsel declined to move for dismissal. Constitutional right to an impartial jury. The Sixth Amendment of the United States Constitution guarantees the right to trial by an impartial jury. California law further reinforces this right under Cal. Constant. Art. I. Section 16, and established precedent requires that jurors be unbiased and free from connections to parties, witnesses, or law enforcement personnel that could impair impartiality. In this case, the jury was irreparably tainted. Several jurors disclosed, or later revealed, direct connections to the police, prosecution witnesses, or prior knowledge of the defendant. These connections compromised impartiality and rendered the trial fundamentally unfair. B. Jurors with police ties and conflicts of interest. Jury connections to police. A significant portion of the jury had familial, professional, or personal connections to law enforcement. This created an inherent bias in favor of police testimony and prosecutorial arguments, especially in a case centered on allegations of police misconduct and corruption. False claim of prior case. One juror falsely claimed during voir dire that she had previously been involved in another case with the defendant. This was untrue, demonstrating dishonesty during jury selection. A juror who conceals or misrepresents facts in voir dire violates the defendant's right to candid and truthful disclosures necessary for challenges for cause. Relationship with Officer Charles Dentz. One juror had previously been in a personal relationship with Officer Dentz, a key prosecution witness and the lead officer in the case. This conflict of interest is direct, undeniable, and should have required immediate disqualification. Friendship with Detective Ruiz. Another juror admitted being friends with Detective Ruiz, another key police witness in the case. Such a connection fatally undermines the requirement of impartiality. All the jurors claimed they didn't know of me, when I'm known worldwide and provoked at almost every place worldwide, showing that it wasn't going to be a fair trial no matter what. C. Legal standards for juror misconduct. California courts have long held that even the appearance of juror bias is sufficient to require reversal. See People v. Nessler, 1997, 16 Cal.4 Th 561, 578, juror misconduct raises. Grounds for dismissal, relief requested. Cumulative due process violations. Systemic government misconduct and collusion. Prejudice so severe retrial would be unjust and constitutionally insufficient. Legal authorities, U.S. and California Constitution, People v. Batts, 2003, Strickland. Washington, 4, Caperton v. Massey, 2009, Penal Code Sections 96, 96.5, 147, 182. Violation of Fifth Amendment rights. Judge Gregory A. Dohe. At the start of trial, Judge Dohe instructed the jury that every defendant has the constitutional right to exercise the Fifth Amendment and remain silent. Toward the verdict, however, Judge Dohe lashed out in anger because I exercised that right. He called me toward the stand, stating, "You can stay back there, since you have nothing to say." Such judicial hostility undermines the impartiality of the court and violates U.S. Constant. 5th and 14th Amendments. Cal. Constant Art. I. Section 15 and California Penal Code Section 147, prohibiting oppressive conduct by judicial officers. Judicial violation of Fifth Amendment protections, where Judge Dohe ridiculed defendants' exercise of constitutional rights.